We are in the final stretch of the SEC v. Ripple Labs case, which will determine whether the digital asset XRP was sold as an unregistered security by the company Ripple Labs. Up to this point in the case, we have seen Ripple win every major issue that actually matters. And the major document that the SEC wants to hold on to are the emails that were surrounding the 2018 speech that Bill Hinman gave. Now, Bill Hinman was the director of corporate finance at the SEC at the time. And the markets took this as guidance, suggesting that Ethereum and cryptocurrencies like Ethereum were sufficiently decentralized and therefore not unregistered securities. So all through this process, the Judge Torres, has been very clear about not keeping certain SEC documents to be privileged documents, and that there are documents that should be admissible into discovery process, even if they feel that they may not have the impact on the case that everyone believes they will have. So within this most recent brief that the Ripple lawyers wrote to Judge Torres, there's also the SEC side of this, but we're going to be reading out of the Ripple side of this today. They're going through exactly why these documents should not only be admissible in the case, but also should be public facing. And this is something the SEC doesn't want because they know that there's something incriminating in there. So let's read a bit out of here. Let's read a few excerpts. So we see here on page 2. As this court recently explained, the burden is on the SEC as the moving party to make the necessary particular and specific demonstration of facts showing the disclosure would result in injury sufficiently serious to warrant protection. And again, this is for the SEC expert witnesses that voluntarily gave their testimony about, X, Y, and Z, about, why this is not relevant, why these things should stay concealed, right? But if you're going to put your name on it, that should be a public document, right? Proposed redactions should be narrowly tailored to serve the purpose that justifies the redaction. We're moving on here. Section 2. The SEC has not met its heavy burden to support its request to seal witness names and affiliations. Quote, the SEC's request for an order sealing the names and identifying information of the SEC's own fact and expert witness at the summary judgment stage should be denied. Again, these are requests that should have been made way before summary judgment. Summary judgment is in the last third of a case. While this court granted the SEC's request to seal the names of its experts and the non-dispositive motion stage, I'm doing so, the court explicitly recognized that the SEC's renewed request that the summary judgment phase must be evaluated under a different and more demanding standard, close quote. So again, they're saying that, upwards towards discovery, maybe this would have been admissible, not at this stage in the trial. First, the SEC repeats its prior request to redact the names and identifying information of the SEC experts and out of concern of their safety. Yet, the SEC fails to differentiate between the circumstances of each of the different SEC experts. The identities of 3 of the SEC experts are already publicly known, and a brief period of criticism directed towards one of those experts does not justify blanket sealing of these already public names, right? And that's the same of any piece of content that we see out there, right? You see something on the news, some event that happens to a public figure. We have the right to be on social media and create press about these things and express criticisms of those events and people happening, especially if you're a public figure, right? The slander does not apply in that situation. That an expert's opinion or qualifications may be subject to public criticism should not be a sufficient basis to seal their identity in connection with summary judgment motions, and the SEC has made no showing of any real physical danger to these experts. And that's really the main thing that's going to lead to any sort of granting of the sealing of names, is that there has to be imminent danger. So right here in California, if you want to carry a concealed firearm, you have to prove to the court that you need it for a very specific reason, not just because you think that somebody might get you. You have to have concrete evidence. The SEC's experts are paid professionals whose testimony the SEC has offered in a public enforcement action against defendants with substantial potential consequences for the entire industry. Honing back in on some of the stuff we read in the Ripple reply brief, that was a 64-page document about how this is not just affecting the company Ripple, not just affecting the digital asset XRP, but could have detrimental effects on the entire crypto industry. And that's something we all need to remember, right? This goes for Bitcoin and Ethereum as well. To rebut the strong presumption of public access, the SEC must offer more than an unsupported blanket assertion that the redaction of all information about the identities of all the proffered experts is narrowly tailored and appropriate. And then we got a little bit here on page 4 that we should also read. The Hinman speech documents are judicial documents relevant to the court's consideration of the parties' summary judgment motions, and the SEC has not overcome the strong presumption of public access. Again, they're really just honing in on the fact that this is now public information, and the SEC should have known that when they slammed in with the lawsuit in 2020. They most likely assumed they were going to fold, like a lot of other companies have when these enforcement actions come, but you know what? Ripple's sitting on $1 billion in cash right now. They're well prepared for something like this. At the outset, the SEC's suggestion that the Hinman speech documents are not judicial documents or carry a lesser presumption of public access is incorrect. Defendants relied on these documents in their briefs in support of their summary judgment arguments, meaning that they may have the tendency to influence the court's decision on the summary judgment motions. We continue here. The court now has the benefit of defendants' views regarding the considerable relevance of the statements contained within the Hinman speech documents to rebut the SEC's claim that the defendant's sales of XRP constitute investment contracts under the Howey test, support defendants' fair notice defense, and rebut the individual defendants' alleged recklessness. So you guys can see they're again repackaging all of the things here that will be damaging if these documents are not made public, right? But even if the court ultimately determines that these documents are not admissible or does not rely on the documents in ruling of the parties' summary judgment motions, the Second Circuit has made very clear that documents do not receive different weights of presumption based on the extent to which they were relied upon in a resolving motion. This is the Second Circuit decision from Judge Torres. Now, again, team, if you guys are still holding XRP, you guys should continue to do so, right? You should consider continuing to accumulate XRP at these prices, because this will resolve, in my opinion, in a way that is advantageous to XRP holders, even if Ripple has some sort of settlement that they need to pay over to the SEC.